Wonderful. I think we will get started. Hello, everybody. Welcome to the Cybersecurity Coalition's webinar on the Network and Information Security Directive 2, otherwise known as NIS2. My name is Inez Jordan-Zub. I'm a program manager here at Venable. And a few quick pieces of housekeeping before we begin. This webinar is 60 minutes. It is being recorded. We will share the recording after the fact. If you have specific questions for our 4 exceptional panelists, please use the Q&A function and we will try to get to them at the end. We are very excited to be digging into this topic today. The directive is one that the Cybersecurity Coalition has robustly engaged with throughout the drafting process of both the directive itself, as well as the associated texts, including the implementing regulation, which was released today. NIS2 builds and significantly expands upon the scope of NIS1, the original NIS directive, which, when it was introduced in 2016, was the first EU-wide cybersecurity legislation. 2 notable differences from that first iteration are that NIS2 significantly expands the scope of both essential and important entities operating in the EU to which the directive applies, and it imposes significant administrative fines in the event of non-compliance. NIS2 was actually adopted in EU Parliament in 2022 and came into force in 2023. Yet, as a directive, it needs to be transposed by the individual EU member states in order to apply to companies. We chose today for this event with intention, since October 17th is the deadline for member states to transpose NIS2 into their national law. As we will discuss, the transposition status is somewhat patchwork. As of my count, only 6 member states have successfully transposed the directive into their national law, and many member states have publicly stated they will miss the deadline. So we expect to see a rolling transposition likely through 2025. We are very fortunate to have all of this be contextualized by our 4 panelists, and I will let them introduce themselves and make a special call out to the fact that 2 of them are coalition member representatives. So I'll turn it over to Marnix first to introduce himself.
Thank you so much, Ines. Great to be here indeed, a special day, the deadline for the national transposition of the NIS Directive. Indeed, Marnix Dekker, I'm the head of sector for the NIS Directive at ENISA, the European Agency for Cybersecurity. We support the member states with the implementation of the NIS Directive.
Wonderful. Thanks, Marnix. I'll turn it over to Sebastian next.
Good afternoon, Sebastian Schulter, Senior Manager of European Cybersecurity Organization, which is association based in Brussels. In my role, I mainly work with the end users in cybersecurity, closely following topics of their importance, like the NIS2 implementation, and also building the CTI community as an example. Thank you.
Thank you, Sebastian. Elias.
Good afternoon, everyone, or good evening for those that are in Singapore. My name is Elias Khanzos. I'm Broadcom's Chief Privacy Officer. We are a company that is both in semiconductor manufacturing as well as in software, enterprise software for infrastructure and cybersecurity.
Wonderful. And last but by no means least, Trevor.
Thank you, Inez. Trevor Rudolph. I'm Schneider Electric's Vice President for Global Digital Policy and Regulation. Schneider Electric, of course, is an electrical equipment manufacturer and therefore an important entity under NIS2. So very much looking forward to this conversation.
Wonderful. Thank you all. And I think with that, we can begin under the general theme of implementation. Today is the day for member states to transpose the directive into their national law. But before that, Marnix, maybe you could help us understand what are some of the different measures from NIS1 to NIS2 that need to be implemented now? And maybe you can kind of contextualize why those changes were implemented and what we needed to fix from NIS1.
Okay, great. So, I think I should first start that the NIS2 is really a continuation of the NIS1. We felt it was a really good instrument, worked really well, and so I think there's not a radical change. It's still about resilience, critical sectors. So, as you already mentioned, indeed, the scope of sectors is quite extended. There are quite a few new ones. There's a bit of simplification. There was telecom security rules that were under a separate directive. They are now integrated in NIS2. trust services rules on security also have been integrated into the NIS2, so that's a bit of simplification. As you also mentioned, more entities or companies within each sector are in scope. They're now using size cap instead of handpicking. The explanation there is a little bit under the NIS1, every member state had to look around and see which companies are really critical for my country. And so that was really handpicking. In some smaller countries, it was like 20, 30 companies, very private relation almost between the regulator and those companies. But those companies were really struggling with implementing it. They were often alone in their sector. They couldn't find services. Suppliers didn't know what NIS1 was. And we have seen also an increase in the number of supply chain attacks, where attackers are struggling more and more to get inside the bigger companies because their SOCs are better, they detect better. So now they're trying to get in via the suppliers. And so there's really this realization that if we don't broaden the scope and also start to deal with smaller companies in those sectors, it's going to be really, really hard for the bigger ones. So that is a bit of the background on the change in scope, I would say. I think also the link with physical security of ICT has been a bit clarified. In the past, there was a bit of a gray area. It's like, is this cyber? Is it not? Should we do it? Now the Commission released two legislative proposals, one on physical security of infrastructure and one on the cybersecurity side, and clarifies that the physical part that needs to be done, which indeed is a part of ISO 27001, for example, that is fully part of the NIS2. For member states, there are a few new obligations that have to be done, apart from, of course, running many more sectors. One thing that I think is interesting is this obligation to have a national coordinated vulnerability disclosure policy. That's a very difficult word for saying, if you have an ethical hacker, don't prosecute them. Make sure that they can report their vulnerabilities in the right place. So there's now an obligation for member states to appoint a triage point in the CSIRT so that the ethical hacker can report that vulnerability. There's some rules around that, of course, that have to be clarified. For the companies, okay, the ones that are under NIS1, not so much will change. Maybe the change is there in the management responsibility, I think, where suddenly now the C-level becomes responsible for any security failings. A bit more harmonization we expect in terms of security measures and incident reporting. And I should mention that today the Commission adopted the implementing acts with some more details about the security measures and incident reporting for a few sectors. So go have a look at the news corner of the Commission, you can find it. I can also maybe later put it in the chat if you want. And then for the rest at EU level, not so much changed, but cyber crisis coordination is new, was already up to speed, but now it's formalized in the directive. There's going to be an EU vulnerability database. That's going to be a mirror to the NIST NVD, with a slightly different focus, of course, more with advisories from European CSIRTs. There's a bit of focus on supply chain risk assessments, kind of a continuation of what you've seen in the 5G toolbox work.
Thank you, Marnix. That's very concise summary. I'll turn it over to Sebastian just for a little different context from his perspective on some of the expansions in scope and some of the measures that we've seen in the draft implementing act and now the final one today.
Yeah, of course. Well, what to add to what Marnix already said, I think it was quite a good overview, but maybe I would like to emphasize 2 points. So I think that the number of countries, is the fact that there will be many new companies coming into the scope of the NIS2, and I'm not fully sure whether the companies or security managers are well aware of that fact. And that this is actually also linked to the, let's say, new additions in the supply chain requirements. Probably one of the biggest differences is the fact that what are we also seeing in the Belgian example? So Belgium is one of those 6 countries that has already transposed NIS2, where it basically says that the companies in the scope of the NIS2 have the mandate to impose to their critical suppliers the same, let's say, security requirements that they are under. Which this basically means that indirectly there will be many more companies and sectors affected that are not potentially aware of it at this stage, and at this date. There are also probably to emphasize some changes to some security requirements, as mentioned by Marnix, especially the incident reporting, which remains, one of the, let's say, key provisions and one of the most challenging provisions. So this has been changed a bit. The timelines have been a bit changed, but it more or less follows the logic of the NIS1. Hopefully this time it will work a bit better than the NIS1, so that we don't get to the NIS3 very soon. But maybe that was just from my side to add on what has actually changed. But later I'll talk more about the challenges that we are seeing.
Thank you, Sebastian. And before we dig into that part, it's wonderful that we have two member companies here to explain to us the context of what it actually means in practice to implement NIS2. So I will turn it over first to an essential entity, being Broadcom, and Elias to explain how this has been working in practice, because I'm sure he's been thinking about it quite a bit.
Thank you, and much appreciate the opportunity that the coalition is giving for me to be here and comment today, and the initiative to put this panel in the first place. So I think we need to look at this from a number of aspects. When one is looking at this from the point of view of a large technology company, actually, in many ways, the change between NIS1 and NIS2, I would agree with Marnix. It's not something that dramatic. If you had good security controls before, well, you're expected to have good security controls now. I would also go as far as to say that certainly with the implementing act, there's a lot more particularization and clarity around what the security controls look like. And again, for organizations that have a mature security infrastructure, have a mature security program, a mature security ecosystem, are not going to be surprised. I don't believe that would be the case. At the same time, I think that the emphasis and the focus that NIS2 is putting on the supply chain is a step in the right direction, is something that historically, let's say, we've been missing. I think the bigger challenge in the European scope is not going to be just the NIS2, but the fact that the NIS2 comes together with a number of other European legislations and initiatives. People in the webinar may have seen me speaking in other panels or participating in other discussions or posting on LinkedIn with things around DORA, for instance. So how the cybersecurity ecosystem, because there does not exist such a thing as a company that provides services only to one, let's say, market segment. How the whole regulatory security supply chain requirement overlaps between NIS, DORA, CRA, and the telecoms industry as well are some of the areas that I think we will need to find ways and understand and try to manage. And that, of course, percolates down to things like contractual terms, incident response timelines, and all that. But in of itself, NIS2 defines a good, let's say, baseline from my perspective, strictly speaking, from information security requirements. But then you have to do all the basics right? I mean, data mapping, risk assessment, and all this stuff.
Wonderful. Thank you, Elias. And now to Trevor for the important entity perspective from Schneider Electric.
Yeah, thank you, Inez. I would say the biggest challenge, right, for an important entity, especially a sector that wasn't previously regulated under NIS1. The biggest challenge is, regardless of where you might have your European headquarters, if you have a physical presence in any of the member states, you must abide by that particular transposition. So for a large multinational like Schneider Electric, the obligation quickly becomes 27 different flavors of NIS2 in the various transpositions. And today we only have 6 of those published. So you're operating with a great deal of uncertainty as you go into 2025 as to understanding what those rules may be and the different flavors, as I just mentioned. So this poses, as you might imagine, a combination of kind of technical, administrative, and just very practical challenges for you as an entity to really understand the rule book going forward. And that's something that we're going to have to just track very, very closely, like I said, as we get into 2025 here.
Thanks, Trevor. And now that we've had a little bit of a summary of where we're at and what the directive entails, I think it might be worthwhile to dig into some of the challenges and hopefully opportunities to overcome them. First things first, as Marnix mentioned, DG Connect and the Commission released their final version of the implementing regulation associated with this directive. The text, as well as the annex document, serve as kind of the reference of technical controls and security measures for how member states should think about putting this into their national law and what companies will need to comply with. I will remind folks that in the prior iteration of NIS, the NIS1 Directive, companies had a lot more time to review this implementing regulation than they do in this scenario. So we struggle with less time, but we make do anyways. That might be one of the challenges, and I'll turn it over to Sebastian to highlight that and some of the other challenges when it comes to putting this into practice.
Yeah, I mean, fully agreed with you, Ines. I mean, but I think it should be also emphasized that that NIS2 is coming in a phased approach, right? So companies, even though tomorrow is the deadline for transposition, you do not need to comply by all the security requirements tomorrow. So this varies across the countries. So there will be a registration period, a few months, and then there will be a period when you will have a time to adapt all the necessary measures, which ranges from few months to few years, depending from country to country. So here is already one challenge where you see that there are completely different timelines across the countries. But speaking about the challenges itself, well, we ran a survey actually a few months ago across Europe among 155 organizations. And what we realized is also, I mean, Ilias already said it well, that the large companies which are with a strong cybersecurity maturity should not have that many issues to adapt to NIS2. Here and there, some adaptations, probably with their incident reporting, let's say, schemes. But we realized that the NIS2 will disproportionately affect a few categories of the companies. And in our opinion, as an association that represents really a wide range of stakeholders from small to large to public and private research, etc., is that it will be mainly the medium-sized companies that will be heavily impacted. It will be newly introduced entities in the scope, as Trevor has pointed out. There will be also companies which have traditionally lower cybersecurity level. And those categories, maybe we should think in a way of how to provide support to those categories of companies, because in the current way, maybe there's too much emphasis on the sectors compared to the size of the company. So I would encourage the stakeholders to think in that direction. Of course, everybody has the common goal to make sure that all companies that will be in the scope implement those regulations, but some will need more help than others.
Thank you, Sebastian. And now I'll turn it back to Ilias for any thoughts on some of the challenges that companies, including Broadcom, might face, especially as we think about the rolling deadline and operating across different member states.
Actually, I would want to begin by acknowledging as well the point that Trevor made previously, because as I said, in our case, we're both a manufacturer of semiconductors as well as a provider of infrastructure software. So if I had to, let's say, to be critical, I would say that the point that he's making about 27 implementations, actually in our situation is the definition of duality. We have a lead authority from the point of view of the software business, and then we have local implementations from the point of view of the hardware business. So in a scenario like that, it becomes really important to try to standardize the information control, security controls across the different environments, which brings back, if you like, the discussion on things like, for instance, the Delegated Act. It's very good that we have detailed requirements around controls that need to be in place. On the other hand, NIS2 is there to cover a very large scope of companies. So what I want to make sure is that whereas we have a list of controls, we also need to allow for the lack of a better word, compensating controls. I need to be able to look at my security environment and say, I agree that I need, controls 1, 2, 3, and 5, but control 4, I will achieve it, but I want to be able to achieve it using slightly different means than the language verbatim that is inside the text. I think as you're looking at this from the point of view of you're a retailer, or you are a hardware manufacturer, or you are a provider of some other, let's say, business service, you would want to manage that requirement accordingly. Predictably, everyone that I know of has at some point complained about the 24 hours initial notification and then 72 hours subsequent. Right when we got literally, I'd say, the planet to agree that 72 hours under GDPR was a good standard, then we squeezed it down to 24 and with an initial notice about there something being wrong. I've had a lot of discussions with agencies. We need to see how this will be implemented in practice. I think, and I want to acknowledge the fact that we've seen improvements there in the delegated act and how this is going to play out. At the same time, because of the concerns that have been raised, what we also see happening is we see on the contractual side pressure, meaning the customer sees the number 24 and goes, oh, if it's going to be 24, I need to be notified in 12 hours because in 24 hours, my regulator will know. And then this notion of initial notification in 24 hours, certainly if it's a serious incident, you don't know, you know very little. It's very difficult to know enough. So what it is that you're actually notifying and what is the action that will be taken on the basis of that information, all that's unclear. Another topic that has come up in our discussions is to what degree, and this is also relevant in the context of DORA, by the way, to what degree does the incident response process becomes more regulated in the sense that because you need to meet those legal deadlines, there are specific things that you as an investigating team needs to identify and respond to and answer, which may be relevant for the notification, but may not be actually relevant for the investigation. So these are, again, some of the challenges which we will need to see how they will play out in practice.
Thank you, Elias. Trevor, would you care to add your perspective on that?
Yeah, so and as I started with a challenge, right? The practical implementation challenge of 27, it's actually 27 plus 1 if you consider that the UK is going to do something similar very soon. But maybe I'll pivot to, what we're doing about it, right? And that is, what we did is we surveyed the draft transpositions and the finalized transpositions that we had several months ago. And we basically tried to determine what was the most strict version. And at the time, the most strict version that we had was the French transposition, because they provided, I think, essentially 20 controls that relevant entities would have to comply with after the transposition, of course, is finalized. And we use that, we consider that as our base text. And then we, began an internal evaluation against those 20 controls, and we proceeded from that point. So what we're going to have to do, though, so that's kind of the beginning of the process, right? So that's our base text, is the French 20 controls. And then we're going to have to essentially create like an NIS2 plus transposition, where we take additional pieces from the other relevant transpositions and then layer on top of those 20 controls anything else that might be relevant to Schneider Electric, depending on where we operate within the European Union. And that NIS2 plus transposition that we will effectively curate within the company will be the rubric that we use moving forward into 2025 and beyond. And that's what I would recommend to other entities that have a physical presence in a variety of member states, because I don't think there's another solution. But that's what we're doing.
Thank you, Trevor. And before I go back to Marnix for a question on the role of the NISA in this process, I'll just turn it back to Sebastian. I do see we have a message in the chat. It's related to what we've been discussing in this moment. Sebastian, you had mentioned that despite the deadline of today and tomorrow, the issues of compliance will not be done today or tomorrow. Could you provide a little bit more context for our attendees? What is actually the timeline that one must expect, and what are the considerations that you have to give based on where you might be operating? It's a big question, but you can.
Yeah, I was muted. Sorry. Actually, I would be happy to just give you one-sided answer, but unfortunately, since this is a directive, this varies massively across the countries. So I'm afraid you will have to look at the national legislation to get more details about the process and the timelines. But I mean, in a nutshell, of course, the process is similar in most of the countries. So most of the countries, with the exception of, I believe, Croatia, are following the logic of self-registration. So you should not expect to be notified by your authorities. You should make your own research. I mean, some countries here are doing better than others. So usually there should be some web page with some, FAQ, some kind of a registration page where you will need to insert a certain data. And basically then you are in the system and you should be notified of the next steps. As mentioned earlier, there will be a period when the registrations will be open, and for how long they will run. It's usually few months, so from opening to closing of the registration process. And after that, again, depending on from country to country, you will have some time to implement the different requirements from the NIS2. But I would encourage you to start working on this already now. So the fact that the audit might come in 3 years and not already now should not discourage you to really start implementing the NIS2 right now, because after all, if we look if you look at the essence of all of it, those are not really strict security measures, right? So this is something that I believe should be emphasized, especially to the people that are in cybersecurity industry. They understand that those are a set of, so let's say, basic security controls that in today's interconnected world, it's very important to have basic cybersecurity measures in your company. Not for the matter of compliance with the NIS2, but to protect your company, to protect your supply chain, protect your society. I think that's the most important part, actually.
Thank you, Sebastian. And yes, we encourage folks to check on individual member state transpositions. And I would remind folks that if we look in the case of Belgium, they've taken a kind of staggered and tiered approach through 2027 to ensure full implementation. So this is a journey that will continue for a while. And now I'd like to ask Marnix, as our representative from the wonderful ENISA, what can we expect in terms of support and resources to help companies come into compliance in the coming months?
Oh, that's, I mean, Sebastian said many good things, I think, about the spirit of the directive, that it is indeed not about compliance, it's about keeping the society going. In general, what we preach to the authorities is that resilience is a partnership. And this is really about critical infrastructure that is not in the hands of the government, but is crucial for society. And so there has to be a partnership between the member states and the owners of this infrastructure. The kind of support, obviously, the national CSIRT will expand its service portfolio. Some will go into things like quick scans, helping you quickly figure out if you're vulnerable for certain things. They might even go in the direction of scanning and sensors and so on. So you will see better support from CSIRT, broader support. In many countries, there was a bit of a prioritization model where if you were on the NIS1, you were helped more quickly, and if you weren't, a bit later. Many countries will also issue guidance, of course, what they mean with security measures. I hear from many authorities that also France said this clearly. They said we will focus on the carrot, not on the stick. The stick is already out there. It's the ransomware. We are going to make sure that it is good for companies to be under supervision, to be considered critical infrastructure. So everyone is really focusing on the supporting side. Maybe coming back to supervision a little bit, this is maybe not so well understood, but most countries will adopt a phased approach instead what is said already, and also a mix of ex ante and ex post supervision. And with ex ante supervision, indeed, maybe a sweep of the sector to see where they are, what are some of the issues, but that will be very high level. Ex post supervision is much more focused on incidents. So you might have had a big power cut, stuff went down. I need to figure out what is the reaction of the sector to that issue. Do they have enough diesel in their diesel generators, these kind of things. So most authorities will adopt a mixed approach there. The resources of the authorities are not unlimited. And don't forget that after the transposition is done, there will be new authorities that still need to start doing cybersecurity from scratch. So there will be a bit of time before these come up to speed. And I quite agree with the previous comments about the sectorial approach. That slowly we start to see that the economy is so interconnected that players are dealing with several sectors. And I would agree that indeed for the medium and the smaller companies, especially the ones that are delivering across the borders, supply chain for, I don't know, space or telecoms or something like that, they will really struggle with the 27 rules that also Trevor highlighted. I think everyone had a look at the Draghi report. Maybe the head of the European Central Bank has said, look, Europe has a problem with competitiveness, and if we continue with these 27 different rules, which is really 27 times the number of sectors that you're dealing with, actually, it's not going to work. So I think for all of us, it's good to go towards one framework. We're trying that hard. Industry plays an important role there, I think. So yeah, let's move in this direction.
Thank you, Marnix. Case of NIS1. We have technical guidance provided by ENISA as part of the directive. Is that something we can expect with NIS2? And will it make reference to what the directive mentions, national standards and best practices?
Yeah, indeed. So the implementing acts came out now today. They will be in the journal a bit later. Indeed, as was said already, they don't apply yet until in your country the authorities appointed, the law is in place, and so on. We will provide technical guidance, really, that maps from these implementing acts to industry standards. Also, we're going to make a mapping between the different national frameworks in that document. And generally provide a bit more explanation about what we mean with those security measures. So that will come out in the next couple of weeks, months. Still need to figure that out. I just had a good discussion with Elias about that topic. We want to make sure that it is well validated by industry. But yeah, I expect that really soon. Definitely over max end of Q1. The final piece, but I think you will see us publish it a bit earlier.
Wonderful, thank you. We look forward to the publication. And now I will continue on and go back to Trevor and kind of discuss what are some of the things that member states might be able to do to help alleviate some of the challenges we've highlighted, especially a company like Schneider operates in many jurisdictions. What are the things that you might be looking for from member states beyond making sure their transpositions occur accurately, thoughtfully, and with haste?
So first and foremost, talk to each other, right? Member states should be talking to other member states in a very active way. I would say on not just the text of their transpositions, but also on coordinating enforcement so that it just makes sense, right, for both the enforcement goals and outcomes, but also the regulated entities. Wherever possible, try to harmonize. I fully understand that this is a directive and not a regulation. But I think we all want the same thing or same things as it relates to the security of the European economy, and thereby the global economy, right? This is very much, from my perspective, part of a broader set of global regulations, right? That's very, very important. Let's start there. Let's harmonize where we can and keep up the conversation between member states, because that's going to be crucial, so we avoid duplication wherever we can.
Thank you. And Elias, you've mentioned other EU regulation and how this might interact. Do you have anything to add on Trevor's point, especially in the context of DORA and other related regulations?
Yes, actually, look, it's difficult to disagree with Trevor, right, on such good points. But the only thing I would add to that would be that given the complexity, this web of interaction that has been created between the different regulations. Again, it's really important to remember, just because you are a technology company, that doesn't mean you're servicing one customer or one sector. Okay, so it is perfectly possible that you've got an organization to whom simultaneously NIS2, GDPR, DORA, and CRA apply. So how do we make sure, and picking Marnik's, which is difficult to disagree as well, Marnik's point about competitiveness and the Draghi report, how do we make sure that we make Europe more competitive? It's about reducing cost. It's about making compliance easier, because I don't think also anyone will disagree that cybersecurity is not important, that cybersecurity is a goal that we should not be aspiring to. So it's about also making sure that the regulators talk to each other. It's about making sure that, yes, the member states coordinate this, but in what I just described, we're looking at, what, 4 different regulators? Think about this for a moment. 27 member states, 4 different regulators per member state. And I haven't touched the data legislation, right? No EU AAI Act, no Data Act. After a while, if they meet together, it's not a meeting, it's a demonstration. I mean, it's just too many people. So it's very, very important to make sure that there is regulatory coordination intra-regulators, not just at the member state level, which is by definition critical, right? But then how also do we make sure that what's done at the data protection space is reflective in the supply chain? Because as part of the supply chain, people process personal data, all those rules about sub-processors. Those same supply chain security controls need to apply in the context of NIS2, but additional transparency requirements are in the context of DORA. So as an organization that would have to comply with all of that, how do we make sure that there is a consistent framework passed down from every regulator is actually key. And I think there's good incentives to do that.
Thank you, Ilias. Sebastian, you think about this a lot too. Any thoughts to add on what member states should be doing and thinking about, and just generally the realistic timeframe for implementing? Ooh, you're on mute.
Yeah, again, well, I mean, I can just reiterate what others said. They really need to collaborate. I mean, we know that that this is a directive, but that we would expect. I mean, I personally hope that there would be more alignment, you know, on how they would, you know, transpose it to the national law, because there are, you know, different forums and groups where member states meet consistently. For example, the NIS cooperation group. So for us, it was a bit surprised that there is still a bit of divergence, you know, as it was rightfully noted. One of the main challenges for the companies will be the fact that some countries emphasize prefer the ISO standards, some prefer NIST, some like to use combination of both or add some other let's say OT related controls. Some of them say that ISO is let's say equivalent to being compliant with NIS2. Some others say no, they just provide it as a good example. So I think ENISA is doing here a great job for everyone for creating, let's say, the mapping of security controls across the main standards. But still, this is a bit varying, because if you are already if you're a company that's already, let's say, ISO certified, and then you have, for example, in Italy to adapt your, you know, security systems to NIST framework, that might be a bit of an issue. So we see that as a challenge. There's some other divergences, maybe to mention. The scope is different in some countries. Maybe just to mention to our audience that, right, the countries cannot, let's say, make less strict the requirements, but they can make it more strict. So some countries have decided to also add some other sectors into the scope. Some countries have also decided to adapt a bit the incident reporting provisions. We have seen in some drafts of one country that they would expect the incident to be reported in 6 hours. Let's see if that would be passed in the end. So this is a bit varying, I must admit. We are here. I mean, a lot of multinational companies obviously will be impacted, and it was rightfully noted that if they have to take care of, align with all those differences, I'm afraid that we are not reaching the expected goal here.
Thank you, Sebastian. And yes, it's a good note. The NIS2 Directive is a minimum harmonization law, so member states have to meet it, but they can indeed go beyond it. While this webinar is focused on what is coming on the journey of NIS2, I will note that we've had a few questions from the audience on some of the actual substance of the directive, and I want to make sure we speak to it. When it comes to the topic of corporate executive liability, this is one that has gained prominence not just in the EU, but in the US as well. The NIS2 Directive does introduce liability for C-suites based on non-compliance. And I would like to turn it over to Elias to maybe speak to what that means.
Well, it means that different individuals within the management organization, depending on how that management is structured and how the legal entity is structured, will be accountable on the cybersecurity. They need to show that they've been diligent in taking the relevant measures to ensure an appropriate level of compliance in the light of the risk that their organization is facing. So it's definitely, I would say, it's definitely novel from an EU legislation point of view. At the same time, I would say that. Again, I'm sorry, I'll refer to DORA because it's another concurrent legislation. The position taken there is that there needs to be management responsibility for ICT risk and ICT third-party risk. So without judging, let's say, the provision, it's certainly fair to say that it appears to be consistent across the latest batch of EU regulation when it comes to cybersecurity, that this is an approach taken by the EU.
Thank you, Elias. And folks, if you have any more questions, please remember you can use the Q&A tool. We are trying to get through all of them.
Maybe I can say a little bit about that. We survey companies about how they're doing with security, and we notice consistently that when the CISO reports directly to the CEO or directly to the board, that the cybersecurity measures in general are much better in the company. There's a bit of a correlation there. So I think it is a bit of a going with the time. In the past, the CISO was often more technical role, reporting maybe to the CIO, was not really invited to the board. I think the more mature companies, they realize that this is really C-level and important. So they have changed this setup, and they want to speak with the CISO at board level meetings. And I think the directive here kind of formalizes that trend and says, yes, we want C-level to be really aware of the risks and the choices that are made here, and to sign up on those things. But personally, again, it is a partnership. What I already said, I don't expect authorities to grab to the heavy-handed fines immediately. I don't expect that.
Thank you, Marnix. And two slightly related questions. We're getting a little into the weeds of the directive here, but we made mention of supply chain threats, and one attendee would like to ask, does the implementing act and will the ENISA recommendations address logging in threats like phishing? I don't believe so. But...
Oh, wow. So I can say there are specific provisions around email security. DMARC, SPIF, DKIM, DANE, so the usual. So that should address phishing. I think the other part was on supply chain. There's two levels to this. Indeed, there's a switching culture where I believe in the past it was enough to say you're ISO certified. Nobody would ask you questions about your supplier. Nowadays, with the geopolitics that we're dealing with, companies are more and more asking, customers are asking you, who are your suppliers? Want to know. Essentially, the NIS2 asks member states to keep track and keep account of the supply chain risks that have been identified in larger EU coordinated risk assessments, like the 5G toolbox, which was focusing mostly on high-risk suppliers from China, of course. But for example, also the Nevera risk assessment, which focused on the new war at the eastern border of the EU, the Russian-Ukraine conflict. So yeah, I think, again, this is a part of a wider trend where you have to be more transparent about your suppliers, more aware where are you sourcing your products from? Doesn't mean that you need to exclude certain regions, but definitely you need to be mindful of what customers you're dealing with. And if they are also fine with the routing their data through those areas, or then you have to be more mindful about that nowadays.
Thanks, Marnix. Elias, I see you have your hand raised.
Yes, I wanted to comment that I definitely agree with Marnix that this is a tendency that we see across the board. Already this has happened back with data protection legislation and the standard contractual clauses. Then obviously has continued to a very large extent with DORA. In fact, in the case of DORA, it goes as far as to treat third-party suppliers that are running a critical outsourced functions. If they don't have presence within the European Union, there's a supply risk. So we definitely see that the emphasis on the supply chain. And again, that's not necessarily a bad thing. I think where the challenge begins, and this is not so much in the context of NIS2, but it's in the context of other EU legislation, is the level of diligence and the level of depth that will be expected of the suppliers, of the providers as part of their diligence of the supply chain. So know your customer or know your supplier, but to what degree to what depth and level should you know your supplier? I say this because given the complex and interlinked nature of supply chains in the technology space, one particular function may have 3, 4, 5 subcontractors down the line. None of them would be necessarily a risk from the point of view of geopolitics or sourcing. Nevertheless, there is a limit to the degree of invasiveness that is possible on grounds of transparency to contracts that essentially we or downstream suppliers are not parties to. So, and I say that again, this has really come up in the context of DORA, not in the context of NIS2, but it is a problem that we very much face because on one hand, the regulator comes and says, I want to understand the downstream supply chain of the essential functions, but then what is essential function? I mean, in the context of a data center, we end up saying that essential then will be networking and electricity, because without it, the data center doesn't work. But is that the kind of transparency you want us to give you? Or, you know, the first level +1, for instance. So these are the kind of discussions that need further clarity for a measure that is more or less correct.
Thank you, Elias. In our last few minutes of the webinar, I want to turn it to final guidance for the various attendees and the companies they might represent on what to do next. Sebastian, at the beginning, you referenced the important need to register with your respective supervisory authorities in the member states that one operates in. Member states might have different dates for when you need to do that by, based on their transposition. So it is important to acknowledge that. Beyond that, our panelists have also mentioned the need to simply review your own company's policies and procedures in reference to both the directive and the finalized implementing regulation. And I will try to send that out as a link after the webinar so everybody has access to the document. But I'd like to turn it back to Trevor for what else do companies need to be thinking about both now, in the coming weeks, and the coming months?
Yeah, I would say, and Sebastian, I think already alluded to this earlier, right? If you're new to this topic and you're looking for a rough proxy, right? An ISO 27000 audit is a good rough proxy. The only thing I would add to build on Sebastian's earlier point is if you've ever done an ISO 27000 audit, you know that there are a couple of important things. Number one, determining the scope. What is in scope and what is out of scope of that audit is not a trivial matter. It's not an easy matter. And doing the audit itself is very labor intensive. It requires a ton of documentation. This is not something you can do over days. It's quite a lengthy process. And that is, you know, if you don't want to wait for the full 27 transpositions, looking at the controls of 27,000 would be a good, I would say, logical first step to get you on a good path to compliance, regardless of whether you're essential or important.
Thank you, Trevor. Elias, anything to add?
So, couple of thoughts. First of all, the point that one mentioned about ISO, couldn't agree more. And in fact, I would turn to Marnix and say, NISA has done a very good job on NIS2 and tools. We need that kind of help for NIS1 and tools. We need that kind of help for NIS2. So anything that the agency does in that direction is absolutely welcome. My reaction would be something along the lines of, even if you don't have ISO 27001, literally take a list of the controls and then go through your own practices. Try to understand what it is that you do and what it is that you don't. Have a table, green, amber, red. How many do you have red? If you add them together and you walk out with, there are 120 controls there, and I'm doing the 100. Well, that's not a bad spot to be. So something as basic as that would already be a big help. And the other thing I would definitely suggest is, and again, this is not necessarily rocket science. This is basic good cybersecurity. Figure out, have a list of who your critical suppliers are. What do you know about them? What do you know about what they've promised to you? Where do they put the data? If you've got these steps right, well, you're definitely in a very good path towards compliance.
Wonderful. Trevor, I see your hand raised.
Yeah, just to add on the supply chain piece. So number one, for those who haven't read the annex yet to the implementing rule or implementing regulation, it has a whole section on supply chain security. In addition to that, a number of the transpositions that we've seen, at least in draft form, are going to tackle supply chain security from the standpoint of addressing specific high-risk vendors. So that's something else that is different depending on the member state you might be in, but something that is very, very important to take a close look at.
Thank you both. Sebastian, what else do companies need to be thinking about?
Well, I think that it was already well said, let's say from the others, but I mean, nowadays, I think it's you must have already heard about NIS2. Do not be lazy. Do not delay your actions. It starts from the implementing basic cybersecurity measures, security awareness, etc. You need, I mean, I can suggest that if you really lost, that you contact your national CSIRT. That would be a good first step. I think that they would be able to guide you, and they would be happy that you were proactive. And by the way, that could potentially help you later also with the audit, as you have showcased already the proactiveness in the initial stage. Just try to get engaged, get around different industry associations. I mean, there's plenty of sectors in the scope. I mean, you as a company so you should be in some of those associations. Try to join different communities of experts, etc. But maybe I would like to add on what should be more done from the member state level, not on the company level, just very few points. I think that we need to focus on three key areas. So they were mentioned already many times during this webinar. So one is the supply chain. Again, many companies are uncertain whether they will be in the scope. And if they do not anticipate being in the scope, well, how can we ever expect them to be compliant? The other thing is incident reporting. One thing is the timelines, which are quite strict, but we believe required. The other thing is that with all the upcoming cybersecurity regulation, we will get to a point that if you have a cybersecurity incident in your organization, you might need to report to several different authorities. If the breach is data related, you need to report to the GDPR authorities. If it's on the entity level, NIS2. If it's related to your product, then CRA. So here we are already anticipating a situation where you will have to report same incident to 3 different authorities, probably using 3 different templates. And here I'm only talking about one country, right? So not even taking into account reporting to all the in all the other countries in the EU. So I would really, if I focus on that, because this will become very, very quickly a big problematic point. And finally, resource constraints. In our survey, we've noticed that 2/3 of surveyed companies that will be in the scope do not have a dedicated budget for the NIS2 implementation, 1/3, which has, let's say, allocated budget. They say that it's usually in the range of 5% of the total cybersecurity budget. So this is again varying, and I think maybe we should think in a way that authorities provide more financial boost to those earlier disadvantaged entities. So yeah, that would be my recommendations.
Thank you, Sebastian. Marnix, is there anything you have to share in final parting thoughts for both companies? And we thank you and look forward to the continuing partnership of ENISA as we get started on this.
Yeah, well, thank you. I mean, great to be on a great panel. I mean, keep nodding when everyone is speaking. I mean, Sebastian, Elias, Trevor, really great points. I would like to repeat what I said. Resilience is a partnership. This is not about compliance. This is not about the rules. This is not about regulation going against the business model of companies this should be a common goal. There's geopolitically, there's quite a lot of stuff going on. The supply chain story indeed seems a bit heavy, but bear in mind your supplier with 5 FTEs, 10 FTEs. If the attacker cannot get into your networks because your SOC is detecting well, they will go to the supplier, and these guys, they don't have the same level of security. So maybe don't treat it as another compliance obligation that you're going to impose on your core supplier that are already struggling. Try to see if you can support them and help them, and maybe help them protect themselves. So there's good initiatives there. I can mention the chip manufacturing company in the Netherlands, ASML, who have an entire framework for supporting their suppliers. The closer you get to ASML, the more support you get. The requirements are also more heavy. But yeah, try to look a bit broader than the perimeter of your own company, because let's face it, nowadays we get stuff from left and right. We ship it into the company. That's an easy way in for attackers. Yeah, and then for the rest, I think, yeah, we've said this: geopolitics, a strategic position of the Union, and of our industries in general. That's going to become more and more important question in the future. So yeah, expect more geopolitics in cybersecurity. I would think it's going to be less technical in the future.
Thank you, Marnix. And with that, we are at time. On behalf of the Cybersecurity Coalition, I would like to extend my deepest thanks to our 4 lovely panelists for helping explain a lot. And thank you to everybody who joined us. I urge you to follow the Cybersecurity Coalition page on LinkedIn. And if you have any questions, please feel free to reach out to me. But wishing you all a great rest of your day, and thank you again.
Thank you all.
Thank you.
Take care, folks.
Thank you. Goodbye.